Good afternoon. My name is Danielle Bouldry, and today we're going to take a few moments to look over working women and maternity leave. Over the course of today's presentation, we're going to define maternity leave for our purposes, examine the significance of mothers taking maternity leave, as well as the barriers that prevent it. We'll take a look at women in the workforce, and an overview of legislation both at the federal level and for the state of Oregon. We'll examine employee protections and then examine a couple case studies. Maternity leave is an extended leave of absence from an employer leading up to and or following the birth of a child. This time has a multitude of functions. It allows time for a mother to physically recover from labor and delivery. It also allows for time to establish a bond between mother and child and establish breast milk if the mother chooses to breastfeed. Maternity leave carries a wide amount of significance. Following labor and delivery, there are physical limitations that can make work difficult. Some of these relate to the fact that women are recommended to not lift more than 10 pounds during the first 3 weeks post-delivery. This time frame can be significantly longer if a woman is required to have a cesarean section or experiences other complications. Women are also advised to abstain from exercise for at least 6 weeks post-delivery. There are also mental health risks of returning to work too early. 9 to 12% of women experience postpartum depression, and studies show this is higher in women who return to work in the first 3 months. Higher stress levels related to balancing professional and parental responsibilities further impact the increased risk of postpartum depression in new mothers. Breastfeeding also, according to experts, takes typically 3 months to establish a stable milk supply for women choosing this path. Breastfeeding, while a personal choice, is the clinical recommended method of providing nutrients to infants. Returning to work tends to have a negative impact on breastfeeding related to time away from the infant and using a mechanical pump in place of nursing the infant directly. While the barriers that prevent women from taking a maternity leave vary family to family and case by case, 2 global assumptions help summarize these areas. First, the fear of negative effects to a reputation in the workplace. Some women fear that if they take a maternity leave, they won't be taken seriously, or they will be viewed as less dedicated to their career. There's also financial implications, as maternity leave in the U.S. is currently unpaid leave, and the likely loss of wages lead to an inability to afford basic needs for any extended period of time. Women in the workforce. Over the period of 1945 to 2015, the amount of women in the workforce nearly quadrupled. Over the same period of time, the percentage of men versus women in the workforce also leveled out. As more women entered the workforce, the need for established protections and enforcing pieces of legislation became apparent. Being pregnant or being of childbearing years made getting a job for these women difficult. Prior to 1978, pregnant women would easily be passed over during a hiring process. The Pregnancy Discrimination Act of 1978 was the first significant piece of legislation directly related to pregnancy and was an amendment to the Civil Rights Act of 1964 and was added to their existing sex discrimination section. This act does not apply to employers with less than 15 employees, and it prevents discrimination on the, quote, basis of pregnancy, childbirth, and related medical conditions. This act was also in response to the case of General Electric versus Gilbert of 1976. In the case of General Electric versus Gilbert, the Supreme Court held that the employers could legally exclude conditions related to pregnancy from employee sickness and accident benefits. This ruling fell back on the ruling of Gudulig versus Aiello of 1974, which ruled to allow a disability insurance program to uphold a denial of pregnancy-related claims. Using this 1974 case as its precedent, the U.S. Supreme Court determined that excluding pregnancy did not violate Title VII of the Civil Rights Act of 1964. Pregnancy was isolated from other disabilities based on the nature that only women were affected and that it was usually voluntary. Pregnancy at this point was equated to the likes of attempted suicide, cosmetic surgery, and vasectomies. Following, but significant time later, in 1993, the Family Medical Leave Act, or FMLA as we'll call it for the remainder of this presentation, was signed into law by President Bill Clinton. This law requires employers of 50 or more employees to grant up to 12 weeks of unpaid leave for eligible employees for qualified reasons. Qualified medical and family reasons, as defined by the U.S. Department of Labor, include birth and/or care of a newborn child, adoption of a child, medical care for an immediate family member, i.e. spouse or direct child, or the employee's own personal major medical issue. It is also important to note that employees are eligible after 12 months of working for a covered company and who have worked a minimum of 1,250 hours. Shortly after FMLA was enacted, in 1995, the Oregon Family Leave Act, otherwise known as OFLA, was also enacted. While similar in characteristics to FMLA, OFLA has some noticeable differences. It applies to employers with 25 or more employees. Employees are eligible after a mere 180 days and an average of working 25 hours per week. Care for family members is expanded under OFLA to include grandparents, grandchildren, in-laws, and more. OFLA also offers additional allotment parental leave following Pregnancy Disability Act. Under these pieces of legislation, there are a variety of protections for both the employee and the employer. Employees may be eligible for additional work accommodations. This could include schedule changes, break adjustments, light duty, or job function adjustments. Under the Pregnancy Discrimination Act, employers are required to treat pregnant workers the same as all other workers, including in the process of hiring, layoffs, promotion, and benefits. This act also prevents employers from discriminating against women of childbearing age, even if they believe the job may pose potential risk to the employee and/or their fertility. Breastfeeding is considered a medical condition related to pregnancy that employers cannot discriminate against. Further detailed protections were also implemented for breastfeeding mothers as part of the recent Affordable Care Act. These protections also extend to mothers in a caregiving role of young children. And some conditions or complications of pregnancy may also be covered under the Americans with Disability Act, which may entitle the employee to additional protections. The case of Chipotle versus Hernandez. In 2016, a former Chipotle employee was granted a settlement of $550,000 after a U.S. District Court jury determined she was wrongfully fired for being pregnant. After sharing the news of her pregnancy with her supervisor, she was restricted from water and bathroom breaks. This restriction carried further into allowing her to leave early for prenatal care. Her employment was then terminated after she left work without prior permission to attend a doctor's appointment. It is also important to note that these restrictions were not placed on all employees and targeted only Hernandez. In this case, the employer inflicted unfair actions towards an employee for their pregnancy rather than acknowledging their responsibility to accommodate her under the Pregnancy Discrimination Act. The case of UPS versus Young spans across 9 years from the incident in 2006 until the settlement was reached in 2015. Peggy Young was a UPS delivery driver who sued the company for putting her on unpaid leave while stating she was not able to work while pregnant. The determination that she couldn't work was based on the doctor's note requesting temporary changes to prevent her from lifting packages weighing more than 20 pounds. This decision left Young without medical coverage or unemployment benefits. The Supreme Court ruled in Young's favor in 2015. While the terms of the settlement were not made public, UPS implemented a new policy in January 15, which assisted in making the settlement agreement possible. In regards to choosing between having a career or having children, Young states that, quote, "they shouldn't have to choose, and no woman should." With this case, the employer penalized the employee for requesting temporary job adjustments due to her pregnancy. However, UPS had previously made job function adjustments for employees suffering from on-the-job injuries or other disabilities. UPS failed to recognize that pregnancy required the same treatment and effort to find a suitable set of job functions. Companies have a responsibility both socially and legally to treat pregnant women equally and not negate their worth in the workplace based on their current or potential pregnancy. Solid policies and practices need to be established in order to protect both employees and the employer. As we have seen in the brief case studies, the consequences of not properly addressing these issues may be time-consuming and expensive. In summary of today's presentation, it is also important to note that in today's culture, there's an increasing amount of conversation and spotlight on the topic of parental leave. The U.S. is viewed by many as being behind the times in this arena when compared to other countries. It is likely that change may be on the horizon for working women of childbearing age as these conversations continue to grow in popularity and visibility.